Sue. Good morning. Oh, wait a minute. It's good evening now, right? So Danny's got you. Okay, so are you ready? You want to say something so we can hear you?
Hello, everybody. Actually, you know what? I had everything all planned. I was telling everybody I had this lunch and learn today for the past 2 weeks, even on my calendar. And then last night I went to go sign loan docs for somebody's clients and I forgot this morning.
Yeah, so, well, you know, it just happens more and more the older you get. So welcome to my world, Sue. Okay, so I'm going to let you go on. You've got it, and I'll bow out. Thank you.
Thank you. Bye. Okay, so I have I'm going to go over one item right now. So I'm going to start with the one item that I'm seeing more and more of that I think a lot of you guys might have questions on, or even if you don't, it's going to happen sooner or later, one of your transactions, and that's going to be solar panels. We're having a lot of issues with solar panels. The first issue we have is your sellers are not telling you they have solar panels. So that can be an issue. The second issue is some of these sellers, they're not aware whether it's paid for or they're on a lease. I had one file where they said, yeah, it's paid, don't worry. Are you sure? Yeah, it's paid. We paid it all off. Well, 3 weeks into the escrow, I said, well, I need the termination and the release. Oh, is this it? No. Well, is this it? No. I go, are you sure you paid it off? Oh, yeah, I did. I go, are you making payments? Yes. Then I don't think you paid it off. Oh, so needless to say, that took almost forever to get that released and UCC termination for that particular file. But there's one or two companies that are so bad at responding, it can take up to 30 days. And I kid you not, I closed the file and I just got the termination yesterday. Was it yesterday? Yeah, yesterday. And I closed that file in what, March. So if you guys have solar panels, the first thing you guys ask them, do you guys have solar panels? If you see it, then great. Ask them, do you have solar panels? And then put that in your contract. Are your buyers gonna assume it? Is the seller gonna pay it off? Or are they going to, okay, let's go back. There's 3 options for a solar panel. You can buy it off, pay it off, transfer, purchase, or prepay. A transfer is the buyer assumes everything. The second one is a purchase. The purchase for the solar panels, it's an agreement. It's the agreement itself is not terminated, and they monitor and they maintain the equipment, but the seller pays for it up front. Okay, a prepay is when the seller pays for the whole thing, and the solar company, they don't maintain it, they don't monitor it, and the equipment is yours for the buyer. The only problem is the purchase and the prepaid, they're almost the same amount. I think I've seen maybe $500 difference. The only difference is the purchase is the solar company maintains the equipment and monitors it. The prepaid, not. So, you know, if they're going to transfer it, make sure that, you know, buyers are aware that there's a solar panel, they'll assume it. Otherwise, it's going to be seller shall transfer, seller shall purchase, or seller shall prepay. There's 3 options. So figure out how you're going to do that, because once that happens, your sellers have to contact the solar company and let them know what they want. Once they do that, the solar company will process their files accordingly and send you guys documents, whatever they have that need to be completed, whether it's a transfer agreement, whether it's a purchase agreement or prepay agreement. After that's established, there's an upfront fee of about $395 that has to get paid for them to process this, just to begin it and begin the whole process. And then if it's a transfer where the buyer assumes it, the buyer then has to get approved. And that takes another week or so. And because there's so many purchases, you know, sales right now, every company, including these solar companies, payoff companies, new lenders, old lenders, everybody is just really backed up. And, you know, a lot of them are not working from the office. They're all pretty much working from home. So that makes it even more difficult. There's lack of workers right now, from what I understand. So these requests are coming in, but it's just, they're not able to, you know, process fast enough as much as they want to. Same with escrow, same with title, same with the lender. Because again, there are so many transactions, and refinances being in there doesn't make it any easier, because even when they have a refinance, the new lenders, they require these terminations or subordinations for these solar agreements. And so it's taken so long to get these. So it can take up to 3 to 8 weeks from what I'm seeing right now to get anything to be able to close. So the first thing you want to do is when you guys have a listing, make sure, ask them, because some people forget to tell you they have a solar panel until you see it on the prelim. And sometimes it might not even show on the prelim. And then you're going to end up with, somebody putting a lien on the property because no one's making payments because the seller forgets to tell them. And that's also disclosure issues too. So you probably want to make sure that you do ask your sellers. But if you see it on the roof, obviously you could ask them, do you have solar panels and are they paid for? And if they're not, then how do you want to handle it? Because you have to make sure that you counter the buyers, whether they're going to assume it or prepay or again purchase. Okay, so that's going to be your biggest challenge, is getting those UCC terminations and releases within a timely manner to close escrow. That's the first thing you guys want to do, is start working on the solar panel releases or transfers when you get an escrow opened. Okay, and the second thing I wanted to mention to everybody was on another subject is, when you guys have requests for repairs, don't send it to escrow and say, oh, we decided to give you $5,000. I gave you the RR. We can't have the RR because once you give it to me, I need to give it to my lender, and that'll bring up a lot of issues, and you're not going to fund that loan. So when you guys do those, requests for repairs and you're emailing each other, don't include escrow. When you come to a point where you guys finish your negotiation and decide we're going to either give it a credit or fix it, just give me an addendum. Just give escrow an addendum of how much you guys are crediting for closing costs. Don't include the RR and include escrow in those emails, because I'm not supposed to know. I don't want to know. I don't need to know, and I don't care to know. So just get an addendum after everything's been negotiated, if we're going to give a credit or not. I don't care about repairs, whether they do it before, after, during. Repairs has nothing to do with escrow, so keep us out of it. It'll keep everybody happy and safe. And then the next item we have is the RCSD on page 10 of your purchase contract, if it's a residential, and I think page 14, is it 14 or 12 for income. But if you guys have a trust, an LLC, this is also for the buyer, not just for the seller. If you have a trust, an LLC, or an entity or corporation, you have to make sure you mark that box and put the RCSD in there. We're all going to ask for it anyways, but they put that in there for a reason. So you guys are, it protects the agents as well, because you're not blindly taking a listing or selling to some, especially with the sellers. You're not blindly taking a listing and getting a seller to sign, and he says, I'm the CEO. We find out later on he was the maintenance guy for some company, So again, make sure you guys get that RCSD, because we're going to ask for it. We're going to need it. And, most of the brokerages are asking for a copy as well. So mark that box and include the RCSD. And right above the RCSD box, I'm sure you guys are all familiar, but there's a box where it says seller, subject to seller counteroffer. I get a lot of files, and we had one file where they didn't mark it. I didn't get the counteroffer, so we were processing this escrow with the wrong amount because nobody gave us the seller counteroffer and it wasn't marked, and I had no idea. So if it's not marked, I'm not going to know there's a counter. So, if you mark it and I don't get it, I can always ask for it. But if you don't mark it, I'm not going to know, and then we'll have an issue later on. So make sure that, make sure you guys check all the boxes that need to be marked when you get an offer before you start countering. Just if you glance at it, a lot looks great sometimes, but, those little boxes, they do mean almost everything, because in the end of the day, when I get the file, I'm going to go back and ask you guys for things or addendums, which you guys hate making. It's such a hassle for items that are escrow, that pertain to escrow. And my item, I think, is 20 on the contract. I had a contract here, but I put it somewhere else. So it is, so everything that is in item 20, every item number that is item that's in item 20 of the RPA is what I'm going to be concerned with and I'm going to ask for. Everything else I don't need, like the RRs, that's not part of 20. But whatever is part of 20, I'm going to ask for, I'm going to need it. It's not that it's not me per se, but when I get audited, it protects me and then I protect you and then you protect your clients and then we're all happy that we're not schlepping out a file 5 years from now. Because I don't, like I said, like Dirk said, I don't remember what I did last week. I'm not going to remember what I did 5 years ago. So those little boxes should be marked. And if you have a sloppy contract, if anything ever goes wrong, really, and it does get into a lawsuit, God forbid, if you have a sloppy contract, the first thing that's going to happen is say, well, see, they didn't do this right, and this is wrong, and this is wrong. And it just more excuses to say, well, they didn't do it right. They didn't do it correctly. They didn't do a good job. They weren't professional. You know, they don't know what they're doing. This is the reason why this happened. So, and it is a contract. So, you know, you can't just tell escrow, oh, just do it. It's okay. Because if you guys start saying that, then I'm going to start saying, okay, so then the buyer called me and said to lower the purchase price. It's okay, just do it. I need it in writing. It has to be in writing because this is a contract between the buyer and the seller, not with the agents. It's between the buyer and the seller. So the contract says they need a wire and the buyer walks in with the check. And you say, just take it. I can't. I need an addendum that the seller has signed. Because again, this is a contract that I'm taking.
Sue, if I can butt in here. So maybe you can talk about the multiple counter offers, how you want to limit those. And then the other point, as she just mentioned, it is a contract. So the problem I run into, because I'm typically a listing agent, is I'm relying on these other agents in providing that RPA. I'm not writing the RPA. All we're writing is the counteroffer. So a lot of times you'll have to have it either rewritten, or I've even volunteered to rewrite it for the other agent. So you got to kind of walk on eggshells so that you don't upset these other agents, because a lot of times they just don't want to do anything. They want to keep that paperwork as stated. But you are representing your seller and you're going into this escrow based on this contract. So you want to make sure, to avoid litigation, that everything is done correctly. And back to you. Thanks.
Yeah, so if you can, avoiding a lot of counteroffers. That's, I think, really important, because the more counteroffers you have, the more there is to interpret. And again, interpretation is based on the person that's reading it and how they feel that day, not about what it really means. We have escrow files that go to small claims, and depending on the judge, the same issue, the same item, depends on who the judge is. They can go for the seller or the buyer. It just depends. For the same issue, that number one issue back in the days was cancellation refund. So if you have a clean offer in the beginning, just the purchase contract, clean offer and accepted, that's the best case scenario. But if you do have to do a counter, I really say just limit it to one counter, sell a counter, figure out what they want. Don't go back and forth. If they want to, if you feel like they're going to come back with something else, just say, tell me what you want now. Let's not go back and forth and play games. Because again, when you have more than one or two, it's about interpretation, and then you miss something, and that's what I intended it. But the intent is, again, well, it depends on who's reading it, how it's read. And so there's a lot of factors into it. So I agree with Dirk on that one. I think really the best thing is one nice, clean purchase contract. And like you said, he even offers to do it for the agent sometimes, which is a nice gesture. And so we don't have any questions later on. But that's not what I meant. Or look at the other counter, and you're looking at 4 different counters, and it becomes too much later on. And we don't know what what's actually what it is that they're actually trying to do in the end of the day when you have 4 or 5 different counters. So, and always remember to mark subject to the counter, because I have people that just sign it and then put another counter, and I don't see that either. And then I'll say, well, this is seller counter 3. What happened to seller buyer counter 2? Oh, we didn't mark it. So yeah, that's another thing. marking boxes, again, we're gonna go back to the home warranty. They did a little bit when they revised it in 2018. But remember, when you get it, even if it says not to exceed $700, if it doesn't have anything marked, it's still per contract. You as a listing agent, if you're protecting your client per the contract, if it's not to exceed 700, but there's nothing chosen, it's just the standard. That's not going to be more than $355, $400. Okay, but if they start adding everything up, they can use up all of 700. That's not hard to do. But the problem is, the fact of the matter is, it's supposed to be standard. It's written there for a standard. Everything else is an option. If it's not marked and you're expecting me to pay, I'm going to need an addendum. Because again, it's a contract between the seller and buyer, not the agents, and not what you intend to do, and not the gesture, the generous gesture of the seller, but of the fact that, yes, it's what the contract says. And I have people yelling at me, well, it says not to accept $1,200 and we're only using 700. Yeah, but it says $1,200 standard. And you put in roof, and you put in and you put in this, and you put in that. And I think some people they put in washer and dryer or the roof or something. And I had one listing agent actually tell me, well, I don't want them to get that, because I don't want them to think later on that the intent was we were trying to, give them a warranty, like we're telling them it was okay. It was their inspection, they figure it out. We're not going to do anything else. And so that was a valid point too. So, if it's not on the home warranty, the options, and you see it, right, have them write in. If you want them to use up to 700, that's great, but have them write in, other, buyer's choice at close, or buyer's choice of option. It's typed right there, other, you can type it in, buyer's choice. And that way they can choose up to that amount. And then we don't have to worry later on. And the same token, I did have a client where, he knew what a home warranty was going to cost, a standard, because he had just bought a home. And it said $750. He knew it was going to be $750 because there was no other option. But when we closed escrow and they used all $750, he said, no, it's a standard. Why am I paying $750? Because when I bought a house, he sold and bought at the same time. He said, it didn't come to $750. And so then what are you going to tell your seller? So again, this is a contract between the seller and the buyer. So make sure that they're, that we're covered. Dot your I's, cross your T's. And it is a contract, and that's what I have to go by. So then I'm going to call you and say, I need an addendum, and you're going to be all mad at me. And why? It says $650. And well, because, that according to item number 12, I have to go by this. And what it says is standard. It's defaulted. Like the initial deposits, EMDs, it's a wire. It's standard. They defaulted it that way for a reason. Termite, same thing. They took it out altogether for a reason. So, the contracts are made for a reason for CAR and the Escrow Association, and that's why it's a joint escrow instruction as well. It's not separated. It's together. It's the same thing. And my responsibilities are all within item number 20. And those are the items that I come back to you for. Do we have any questions with the purchase contract and the counters? First of all, I can do with the counters. I'm not trying to get a clean counter, and so they're not making 4 or 5, and then we all get it. Yeah. Okay. And then solar panels. Don't forget, because we have had a lot of files with solar panel issues. And a lot of the homes they do have solar panels now. So when you're purchasing, if you're a selling agent or a listing agent, make sure that solar panel is, addressed, because we've had few files where we had to delay the closing. One file, they almost had to redraw docs because they went to the following month. And so there's nothing we can do without that termination. We can't, the lender won't close and the title won't close. So make sure that's, you guys get that addressed. Any other questions? There was one other thing you guys had. Danny, was there anything else that that you wanted me to?
I'd like to open it up. We've got a good group of our agents here, if there's questions.
Okay,
Any
yes.
questions? You
I'm
can
sorry,
raise your hand, use your chat.
there was that one for the trusts, city reports and the NHDs, okay? So that's what I was looking for that, sorry, Jer.
Okay.
So the NHDs, with the new rules and the laws, the NHD reports are being ordered in the beginning. So if you're gonna order them, yeah, just have them CC escrow and you can get it signed. Most of the agents are getting it signed directly and giving me copies. If you don't want to get it signed and you want to order it, just go ahead and order it, give it to me and I'll get it signed for you guys. City reports, the city of LA, we can help accommodate, but most of the other cities, they have to be done directly by the agents or the sellers. And I think because of COVID, a lot of them closed offices, so they're being done online. So if you have a file that has a city report, City of LA, we can accommodate. If you guys give us the application that's completed and signed, we'll help you order that. But everything else, this, Redondo Beach, Manhattan Beach, they all have to be done by the agents or the seller. Home warranty, if it's seller's choice, then yeah, make sure you guys clarify exactly what they're gonna cover on the home warranty. If it's buyer's choice of company, not to exceed, make sure they write buyer's choice of options as well. RCSD, the representative capacity, if it's a trust for your sellers and the original trustees are deceased, get a copy of the trust agreement in the beginning. If it's the original trustees and they're all alive, then that's fine. But if the original trustees are deceased and these are successor trustees, then when you do the RCSD, you're going to have to write their successor trustees, that capacity for their title. Same with the LLCs. Make sure they tell you if they're the member or managing member or the manager when they fill out the RCSD for the selling agents, because most of the LLCs I'm seeing is they're being purchased by buyers that are LLCs. And then there was one other item I wanted to go over, and one second.
And while you're looking there, Sue, the other item is on cancellations, just so that everyone knows that just because the buyer and seller sign that CC, that cancellation of contract, they still have to sign your escrow cancellation paperwork for funds to be dispersed.
Correct. That's just only if they have funds. So if there's no deposit made and you guys are canceling, then I just get the CC, the cancellation of contract. That's fine. But when there's funds in the file, especially if it's deposited by a third party, which we're getting a lot of, a third party depositor, then that escrow cancellation for escrow has to be signed by both parties. The contract in itself is canceled. We're just talking about the funds, where they all understand it's going to, whoever it's instructed to go to. So I would need that fully executed prior to releasing the funds from escrow for disbursement.
And also on getting back on the trust for, and Carol, then we can go to you. If the property is in a trust, then make sure that the parties are aware that that escrow will only issue that check in the name of that trust. So it's not going to go to an individual. It's going to be in that trust name.
So they're not gonna, we get a lot of people asking us to write it to, so let's say for instance, it's, Carol Gillis Family Trust, Carol Gillis Successor Trustee, the check's gonna go out to Carol Gillis Family Trust, because that's the actual seller. She's the RCSD, again, she's just the trustee of the trust. That's where the RCSD comes into play.
Carol, you had a question?
Real quick, yeah. I have a situation where the father in his wisdom made the 4 children successor trustees. And they don't talk to each other very well. So what's happening is at this moment, the trust get it where two of the children are going to be basically in charge of one property to sell and the other two are going to be in charge of the other. And they're getting a quote legal document to acknowledge this. If this happens and it shows, I don't know exactly how they're doing it legally, but shows the successor trustee as being Jane and Mary versus Tom and Bill. Will Jane and Mary be the only signers for everything? Or do we have to get Tom and Bill to sign anything? Because they're just going to be the receivers of the funds when we close escrow, where Jane and Mary are now the official successor trustees of this piece of property.
That's a really good question, but that's going to be, that would be dependent upon what they're doing. So if they really hate each other, I can see them all going to court and fighting it out, and then the judge will rule. If they're amicable still and they're, still, because you're my sibling, I'm gonna try to be whatever, halfway, cordial. What they would do to save money and time would be to go back to the original attorney, the trust attorney, tell them that to resign. The two, how there's 4 trustees right now, right? The 2 would resign.
I would just to stop. It's been going on for 2 to 3 years.
Mhm.
So there's been a lot of challenges, and they've gone through mediation. They've gone through lots of different levels. So there is a new trust and real estate attorney involved who's going to help guide them.
Mhm.
Been in trust with title a little bit, so I kind of let them know what was going on. Eventually, I'm going to get this listing. We've been working on it for a while, and I'm warning you. That's all I can say.
They really should try to just get them to resign, the 2 to resign, because either way, the money's going into the trust.
Yeah, I don't know. There's so much animosity in these siblings.
Yeah, I don't think they're gonna do a resignation then. I don't see them happen. I don't see that happening.
Not at all, but we'll see. We'll see. Anyway, I was just wondering, because I was just wondering if I'm going to need to get off. If 2 of them end up being the successor trustees, I can get them to sign the disclosures and all the documents and the offer and whatever else. I didn't want to have to deal with the other 2.
Well, now that it's irrevocable, the trust, there's not going to be just 2 successor trustees. What's going to happen is there will be 4, but 2 would have resigned and the other 2 would accept. So that's what I'm saying is if everybody's nice enough, they'll agree to that. But if they're not, they're going to go to mediation, arbitration, go to court.
It'll be a long time coming. Okay, I'll let you know. Thanks, bye.
Thanks, Carol. Any other questions?
Yeah, I do have a question to both Durf and Sue. Good afternoon, by the way.
Hi.
How often do people require a geotechnical report on the existing house? And if it is one of the contingencies, like who pays for it? Who in general be paying for it?
What type of report?
A geotechnical, like a soil report, if a house will stand.
Okay, well, the RPA is written on an as-is basis, so everything is as is, but the buyer, during their inspection period, they have the right to pay for whatever inspections they want. And that's one of the reasons Sue doesn't see this, but one of the reasons that we want that BIE disclosure, that buyer investigation election. Yeah. And so we actually put that in the face of the buyer and say, hey, there's 35 things here, fireplace, roof, chimneys, asbestos, radon gas, all these items that you can check for. What do you want to do? And soil could be one of them, foundation, but that's all done at the buyer's expense, and it has to be done
At the buyer's expense primarily. Okay.
At the time, yeah, within the time frame that they contracted.
Okay, because there is a technical report we've done 15 years ago, and it seems like the issue was fixed, but it's a 15-year ago report. So the buyer wants to know if house is okay right now. So,
yeah, well, and that opens up another thing, because on the SPQ, that seller property questionnaire, I think it's on one of the last questions, it asks the seller, do you have any reports?
Yeah, they're pretty open about it, but it's all 15 years ago.
Well, exactly. And so at the very beginning of that SPQ, it tells the seller, it says, you're only supposed to put stuff that you consider to be material. So that's where it gets subjective. For example, they bought the house 10 years ago and they got an inspection of the house 10 years ago. I'm just talking just a normal house, right? Well, typically the sellers aren't going to disclose that when they sell the house 10 years later because they don't think it's material. And that sounds rational to me, but a buyer, that's also grounds for a lawsuit because they didn't disclose that report, and that isn't a report that they had. So, it gets back to what that seller considers to be material. If they ever ask us as the agent, obviously we tell them, hey, disclose it. Let them make that decision as to whether or not that's material or not.
More agents are checking the environmental.
Other questions out there? Sue, I don't know if you want to mention anything, just getting back to basics about
The contract?
oh yeah, about how everything, it's a different world now than it was 100 years ago when I started, where escrows could not see the purchase agreement. You're not even old enough for that, Sue. But when I started, escrow couldn't see the purchase agreements, and the agents had to verbally tell the escrow officer what the terms were. Well, it's evolved 180 now to where it doesn't matter what we tell the escrow officer, it's only what's on paper, what's in the contract. So everything has to be given to escrow in the form of an addendum, so that then escrow can retype it and make an amendment. So it seems redundant, and that was my point on the cancellation, is that even though parties do that cancellation contract, escrow still has to draw up their paperwork to cancel that escrow. So for some of the old timers, you have to realize that everything has to be done twice. All right, other questions, comments out there? This is your chance. Thank you. Sue, this is really nice. I'm hoping that we can get you back, if not on the monthly office meetings, at least every month or two on these lunch and learns, because there's lots of questions, and I know we are always complaining to each other about what agents don't know. So this is a good opportunity for us to get that information out there. All right, so any last words, Sue, or any questions before we,
I have a question.
Yes.
Becky has a question. Hi, everyone.
Hi.
Hey, Sue, I've been taking the board has had some classes about ADUs and JADUs. Are you seeing any complications in escrow about the ADUs?
Not right now.
Regarding any title or any issues? No,
not right now, but it's not to say it's not going to come.
Okay.
It's just a matter of time. You know what? It's like Durf said, back in the days, even when I first started escrow, I didn't get a purchase contract. The agents would call and they'd give me a list of items that I had to prepare, and I would actually type up my instructions. And it's not so much right now. So everything that the documents, that all the car forms that you're seeing now, like the AAAs, ABAs, ADUs, all of these stuff are all new. It's all being part of the contract, which is part of escrow now. So it's kind of intercombined, but it's also separate, because I'm only responsible for certain things. When it comes to title, you guys, when we get the prelim, I do look at it, but the seller should be aware to a certain degree what is against the property. I'm sure that these people know that they have a lien, because I'm sure they've gotten letters from the attorney's offices that saying that I'm going to put a lien against your property or against you. So I'm sure they're aware of it. There are times when we have cloud and title from a payoff that happened like 45 years ago, and the property went down from their grandparents to their parents to them, and there are payoffs that still show up. So those aren't as bad, because it's changed hands and there's been loans, and so we can handle that. But if there are other title issues, that the buyer, I mean, sellers are aware of, I'm sure there are. This is why they say the statement of information that we've sent out before. And we've sent it out in the beginning when I first started a long time ago, and nobody even sent it back to me. So I stopped giving it to them because they just don't want to get bothered with filling out another form, the statement of information. This actually is something that the title company, if we give it to them, when you guys first open escrow, I will send this along with an open order request to title. They'll do their search and everything can be handled in the beginning if there are title issues. And some title issues take longer than other title issues to handle or to, clear up. So that's just, again, things change, but certain things like getting the SI in place, finding out about the solar, addressing everything in the beginning makes a smoother escrow for everybody. All the way around.
Thank you.
Yeah, thank you, Sue. And also, just as a reminder, everybody, we've got that new RPA coming out by the end of the year. I think it's 16. Right now, I think it's 16 pages. So we'll be having classes on that also. I'm sure Sue is looking forward to that.
Yes. That's
Okay.
what I look for.
Any other questions before we sign off here? All right, so we're all in our office. If you have questions, give us a call or a ring or text, email. We're here. We're here for you. Thank you, guys. Appreciate it. Thank you, Sue.
Bye, Carol. Bye, Griffin. Carol, I can't wait to hear what happened to your file. I'm curious to see what happened. I'll learn something from that file. I want to see how they handle it. Thank you.
All right, bye.